Hi everyone. Today I want to talk to you about some strategic decisions that you can make when you're filing for an extraordinary ability visa or an EB1A and/or a national interest waiver, otherwise known as an NIW. My name is Yalda Hijabi, and I focus my practice primarily on employment-based immigration and family-based immigration. So very brief background, the Extraordinary Ability Visa is available to foreign nationals who have shown through a record of achievements that they have reached sustained national or international acclaim in their fields. Essentially, they're among the top 1% of individuals around the world doing the work that they do. The National Interest Waiver is available to highly skilled individuals that have an advanced degree or show exceptional ability and can prove to the US government that their work is in the national interest of the United States. The EB1A or Extraordinary Ability Visa category is a higher preference green card category, meaning that they're harder to get, while the National Interest Waiver falls under the EB2 preference category, which means that they're a little bit easier than the EB1A green cards to receive based on the requirements that foreign nationals need to meet. However, both cases you need to be highly skilled and accomplished to receive them. Now, what happens if you can't decide whether qualify for the EB1A or the NIW? Which route can you go? Well, the first step would be to talk to a seasoned immigration attorney to advise you about which steps you should take, which process you should go forward. They should be able to let you know that based on reviewing your resume and your documents. But taking it a step further, you also need to take into consideration your immigration status in the United States. So right now, those filing under the EB1A category are current under the visa bulletin, meaning that as soon as their I-140 is approved, so their EB1A visa, they can apply for the green card for most countries. This excludes China and India, of course. But for the EB2 category, there's a backlog across all countries, China, India, Mexico, and Philippines included. So if you have some status issues, this may not be the route to go. However, again, it really goes back to the quality of the documentary evidence that the foreign national has. If I have a client who has a close EB1A case, but maybe a really strong NIW case, and they have status issues, so they want to get their green card ASAP for various reasons, I would file the EB1A, have them premium process it, so have the government review it in 15 days. Of course, there's a higher government fee, filing fee that the foreign national has to pay, but hopefully that will be available to them. And worst comes to worst, it doesn't get approved. We repackage the filing and submit it as a NIW. If it does get approved, then great. But let's say they have a really weak EB1 case, but a really strong NIW case, still have status issues. In those circumstances, you can suggest for the foreign national to do the NIW, consider changing them to another non-immigrant visa status while you're working on the NIW application and the I-140 is submitted. And in those circumstances, recommend for the foreign national to consular process their case, so file for their green card outside of the US rather than within by adjusting their status. So there's a lot of strategic decisions that go into these cases. They're very case by case, so it's really, really important to consult with an immigration attorney that specializes in these cases and can really work with you through the process step by step. So I hope that was helpful and look forward to discussing more of these visa options in the future. Thank you.